Hello, everyone.
Welcome to today's program titled Employee Benefits in a Time of COVID-19. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code may be read during the presentation that may be required on all CLE attendance affirmation forms. Write the code down. If you hear it, it will not be reread, and it is required for CLE credit. Copies of this webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. And at this time, I'd like to turn it over to our speakers. You may begin.
Thank you very much, and hello, everyone. Welcome to our webinar on employee benefits in a time of COVID-19. I'm Diane Dygert, the chair of our Employee Benefits and Executive Compensation Department. First, I want to start out by wishing everyone well. We truly hope that you and your loved ones are all staying well, both physically and mentally, as we all do our part to combat the spread of this virus. Things are evolving rapidly in the employment and benefits space. Just today, we've had a new version of the relief bill from the House, which is 1,100 pages long. To help keep you up to date, our cross-departmental COVID-19 task force is presenting a series of webinars this week on the impact of the virus on our clients' businesses. Today's webinar is exclusively focused on the benefits aspects. We will be following this webinar with one on Wednesday related to the more general employment aspects in the Families First Act, where your questions on sick and family leave can be answered. We see a number of pre-questions already submitted that are more related to that side, so those questions are really focused, would be part of Wednesday's webinar. And then finally, on Thursday, we're going to be hosting a webinar on the implications of a remote workforce on trade secrets and intellectual property. So please be sure to sign up for those and join us for those webinars. And of course, it wouldn't be a law firm webinar without the standard disclaimer. So I have to tell you that this presentation is for informational purposes only. Nothing discussed during this webinar should be construed as legal advice or legal opinion on a specific circumstance or fact. You are encouraged to consult a lawyer concerning your own situation and any specific legal questions you may have. So after this webinar is over today, after it's complete, you'll each receive a PDF version of the slides along with a CLE form to complete. Also, this webinar is being recorded. The link will be sent out to all registrants after the conclusion of the program, as well as posted on our COVID-19 site. I have a link to it right here on this slide. If you haven't registered yet for our COVID-19 site, please do so. You'll be able to receive daily updates on the legal issues that are evolving in real time. So please go take a look at the various resource materials that are available to you out there. And I am serving as your moderator today, but I have with me virtually 5 of my partners who will each be handling certain aspects of the benefits topics we're going to cover. So because we're not together in the same room, I apologize in advance if there's any handoff issues or talking over each other. We're going to do our best to keep that to a minimum. And I think I went past that slide too fast, but here are all the speakers today. All right, so our agenda. So even though we're limiting this webinar to benefits topics, we still have a lot to cover. Ben Conley and Jen Kraft are going to talk to us about health and welfare issues, including concerns about HIPAA privacy that might be out there. Kelly Ventura will then discuss severance, reduction in hours, and furlough-related issues in the benefits space. And then Jake Downing and Christina Sarasol are going to cover retirement plan concerns, both from the 401k as well as the pension aspects. And then finally, Jake will cover executive compensation concerns. All right, so at this point, I'm going to turn things over to Ben Conley, who's going to start our discussion on health and welfare issues. Ben?
Yeah, thank you, Diane. So most pertinent and most important thing we want to cover here this morning on the medical side is the Families First bill and its impact on pretty much all medical plans of any shape and size. One of the primary concerns that you saw coming out of the House's bill that passed in the middle of last week was removing barriers to testing and disincentives that may face people in obtaining a test. So outside of the employer-sponsored plan context, you saw changes to Medicare, Medicaid requiring free testing, as well as a pool of money established for uninsured individuals to obtain testing. But within the employer plan space, there was a broad amendment that would impact, from what we can tell, any group health plan that would mandate that the plan cover at no cost to the participant the testing for COVID-19, as well as any related admission, be it a emergency room admission, office setting admission, or even telehealth related charges associated with that COVID-19 test. Now, to be clear on what this covers and does not cover, this does not appear to require or create any affirmative obligation on the plan to provide long-term treatment for a diagnosis of COVID-19. In other words, if you have tested positive and you were in the emergency room and now you have been, say, discharged, but then you have to go back a week later and be put on a ventilator, those subsequent charges do not appear to be required to be covered at any particular level outside of whatever your plan might otherwise pay in that context. But we do know that many organizations have been approached by the third-party administrator or their insurance carrier and asked whether they would prefer to implement no cost or cost-free coverage for those services at that point. I should also note that, as Diane mentioned at the outset, there are some additional proposals making their way through Congress that might address some additional issues or create additional mandates. We don't want to get too into the weeds on what might be included in those bills because it appeared that the version coming out of the Senate was gaining some steam and had some momentum behind it, but that got a bit derailed last night. Not saying that that's done, but there is now a competing proposal presented by the House that would sort of do different things. So we're going to highlight some of those features that are in those bills, especially when we go through this open issue session. But just want to be clear on the point that there is not, there might be more coming, but at this point it's unclear what those additional bills may cover. So stemming from the Families First Act, which did pass and was signed into law, there were some open issues that remained unaddressed. One of those was whether this mandated coverage for non-network COVID-19 testing and related admissions. It was somewhat unclear from the House bill, but we think that given the goal of the bill, which was to remove barriers to access, the likelihood is that there is an obligation to cover non-network services for COVID testing. A couple additional reasons for that. First, as I'm sure people have been hearing in the news, what's happening right now from a testing perspective is not like you go to your family physician and, have a nice little chat and get screened and then go home. People are being rerouted from their traditional avenues where they might go to get tested to, a tent set up in a parking lot of a drugstore or whatever the case might be, or a different setting entirely because there's a limitation on availability of testing and they might be regionally concentrated in specific areas. So we don't know that it makes sense that Congress's intent here would have been that you just sit around and wait until your network provider has testing available. We think that the mandate would extend to non-network testing. Further evidence, if you look at the Senate bill that was proposed, which again has been hung up a bit, but may get more, but by the end of this call might actually have been passed, that bill specifies that non-network testing is required to be covered, and it specifies the reimbursement rate that must be paid for non-network testing, which is the publicized rate by the non-network provider. I know there's been some concerns that maybe that might lead to price gouging and open plans up to unlimited exposure. I can tell you that the House bill did have a price gouging feature associated with it, not the Families First House bill, the one that's pending, sort of the so-called tranche 3 of COVID relief bills. So depending on which one of those versions pass, I think we'll have clarity and or certainty on the non-network issue, although we still have a pretty strong sense that it is required, and we'll hopefully have some relief addressing that sort of price gouging concern in the non-network setting. Other people have asked, what if my plan imposes a penalty for people who go to the emergency room and do not get admitted? Not clearly addressed in the House bill that passed the Families First Act, but we think that given the intent here, that it would be somewhat risky to impose that emergency room penalty because that could create a disincentive to somebody to go get the test there. This law also created a number of, the COVID crisis generally created a number of concerns for sponsors of high deductible health plans, which historically impose cost sharing or full cost fair market value charges for people before they hit their deductible, except with respect to preventive care benefits. That was fortunately addressed by the IRS, I think now 2 weeks ago, in a notice that said, hey, in light of what's going on, anything related to COVID-19 can be provided at no cost. Testing, treatment, all the way down the stream, telehealth, anything across the board can be covered with no cost sharing if it's related to COVID-19. So some welcome relief there that allows sponsors of high deductible health plans to comply with the law, frankly, right? Because the law now requires that there be no cost sharing for the testing and related admission. There do remain some open issues, though. So among other things, plan sponsors are saying, hey, unrelated to COVID-19, I'd like to expand my telemedicine benefit because my kid has an ear infection, but I don't want to take them to the doctor's office right now, given the risks associated with it. It's unclear whether in a high deductible health plan that could be provided on a no-cost basis. I think what we're saying here is, telemedicine is already the most cost-effective in almost every setting, most cost-effective form of service, so there's already an incentive to use that. That said, we know of many plan sponsors who have said, look, high deductible health plan rules be damned. I'm sorry, should have used a different word there. High deductible health plan rules be darned. I'm going to go ahead and do this because I want to protect my participants. We should note that the Senate bill that has been proposed would create a 2-year waiver for high deductible health plans, 2020 and 2021, effectively allowing those services to be provided at no cost without triggering those high deductible health plan concerns. The other thing we should note on the telemedicine front is that there have been some things playing out on the health provider side. HHS has issued a number of guidelines that have relaxed HIPAA requirements. One of those guidelines effectively tells doctors, we don't care as much about privacy anymore. If you need to get access to your patient, and the best way to do it is FaceTime or Facebook Messenger or whatever other medium you would typically use to communicate with, somebody outside of the health plan setting, that's okay. We won't consider that a HIPAA privacy violation in this context. A few other points I want to highlight before handing it off to my colleague, Jennifer. We've got a number of other questions from folks who have asked about what can I do about leave? And Diane noted that we're covering the paid sick leave and paid FMLA leave provisions of the Family First Act on Wednesday, so we encourage you to join. But another question that we've had pretty squarely in the benefits context is, what about short-term disability? Can I amend or expand my short-term disability policy to provide for some sort of paid leave at some percentage for people who have been diagnosed with COVID-19? There's a number of factors that come into play here. The first is whether your short-term disability plan is an ERISA plan or a non-ERISA plan. You have a little bit more flexibility if it's a non-ERISA plan, which most self-funded payroll practices are. But regardless, you can potentially use short-term disability for a COVID-19 diagnosis, although you might need to amend your plan if you want to recognize that. Most notably, usually short-term disability plans, number one, have an elimination period of 7 days or more, so that doesn't really help somebody who might be sick for 9 or 10 days. And then number two, oftentimes there's a requirement that there be a medical diagnosis. And that's sometimes hard to get in this context, right? Because we're hearing that a lot of people who have symptoms of COVID are being told, look, I think you probably have it, but we don't have the tests, so just stay home and come in if you get sick. So consider whether to relax that standard requiring proof of disability if you're going to rely on your short-term disability benefit in this context. Another pertinent question that comes up a lot, and I'm not going to spend a lot of time on this, but is whether people can modify their dependent care FSA elections in light of everything going on. COVID diagnosis, work from home mandate, child care providers being inaccessible for whatever reason. The short answer here is that specific to dependent care FSA, there's a lot of flexibility in those rules, and we've been fairly comfortable getting to yes on most requested election changes in this context. The one note of caution, however, is that a requirement for an eligible expense under dependent care FSA is that both parents be working if you're in a two-parent household. And to the extent that one parent is not working, unless it's a short-term temporary break, which it might be in the context of COVID-19, that expense may not be eligible for reimbursement. So I'm distinguishing here between a sickness, a COVID sickness, which probably still would be an eligible expense, versus a long-term furlough, which might not be potentially an eligible expense in that context. Final point here is that there's a lot of considerations for clients with on-site health clinics. We're not going to linger on those too long, but if you do have an on-site health clinic, one of the things we're hearing a lot of people talking about is whether they want the COVID screenings happening in that setting. In other words, do we want to bring people with potential symptoms of COVID-19 into our on-site clinic, potentially impacting more people within our population, or do we want to issue a directive rerouting those people to other places? Another pertinent point that comes up in this context is if a clinic finds a diagnosis of COVID-19, can you reasonably expect that clinic will then tell the employer so that they can share that with the population? That's an interesting HIPAA question, and rather than linger on that one myself, I do want to transition this over to my colleague Jennifer, who's going to explore some other HIPAA issues.
Thanks, Don. Yeah, we've been actually getting a lot of questions from our clients over the past few days about what to do with all this information, this medical information coming in about COVID symptoms or COVID-19 diagnoses, and what do we do about it from a HIPAA perspective, both in general and, as Ben notes, in the on-site clinic setting. And the first thing to remember here is, as with anything related to HIPAA, HIPAA only comes into play if that information is coming into or out of a group health plan. So that is generally, if you're getting information from the employee themselves, they're coming in, you're doing temperature checks, they're coming in complaining of various symptoms or have reported a diagnosis. Most of that information is coming into you in your role as employer, not in your role as group health plan. So as a result, that information is not subject to HIPAA. There could still be other state privacy laws that come into play. So as with anything of that type of nature, we generally caution against being mindful of that information and using it to the extent necessary, even if it's not governed by HIPAA. You know, you're not broadcasting things unnecessarily. But most of that information coming in is not going to be subject to HIPAA itself. We have had some questions related to the on-site clinics. If somebody comes in and they get a diagnosis, what do we do with that information? And there's a few things to consider there. Some on-site clinics may not be subject to HIPAA if they don't transmit any health information in electronic form in connection with a HIPAA transaction. So some on-site clinics may have gone through that analysis already. If they are subject to HIPAA, however, there are other considerations about disclosing that information. There are some permissible disclosures under HIPAA, some of which have been somewhat untested until now, till we've had this type of thing. But there is a permitted disclosure that if you have a good faith belief that this disclosure is necessary to prevent or lessen a serious and imminent threat to the safety of a person or the public, that disclosure could be made. I think the thing to keep in mind with any of these types of disclosures is that the minimum necessary rule always comes into play. So if we get some type of diagnosis and there's a concern about notifying people who may have worked in the same area as someone who has a COVID-19 positive diagnosis, we want to be able to perhaps warn people who worked in that area, and you can do that without necessarily identifying someone. So thinking about ways that you're not disclosing any actual protected health information is helpful in this context. There are also HIPAA permissible rules to disclose information to public health entities, and there's actually a number of state reporting requirements to state health departments that if you have you have identified somebody or somebody has come to you that one of your employees has come to you that they have a COVID-19 diagnosis, there may be obligations to report that to various state health departments. Illinois, the state I'm in, has a particularly broad reporting requirement. And in that case, reporting to the health department may be helpful in some contexts because the health department can provide you with some guidelines in how to react if you have an employee that has been diagnosed, which can help provide the employer with some peace of mind that they're doing the reasonable thing in light of the circumstances that are so unusual. The other thing to think about from a HIPAA perspective is with everybody so many folks moving to a remote working policy. We have people trying to administer the group health plan that may be working remotely. And things to think about here is, one, to look at your HIPAA policies or recall whether you have addressed whether people who are working remotely can have access to PHI and whether those policies may need to be revisited or revamped. We don't want to inadvertently trip over our own policies, but also we need to have the health plan still running. And so to the extent some revisions or amendments to that policy are needed, that may be something to consider. Another thing is to think about just in general, what types of protections may be needed for your employees that are working on that group health plan to protect that information, and sending some reminders out to them. Just all the IT departments have been overrun in trying to deal with these remote working groups, looking at it through the lens of HIPAA and what steps you can take to help mitigate that concern and to help your employees be mindful of protecting that information can be helpful as well. With that, I think we'll turn it back onto the severance side. Diane, did you want to do that up?
Yeah, let me just ask you guys a couple of questions that have come in just to clarify. Ben, to you, you mentioned that out-of-network issues were up in the air, certainly for PPO-type plans that have both in and out-of-network coverage. We're struggling with that. What about like EPOs that don't offer out-of-network coverage at all?
Yeah, it's a great question. It's a great question. I mean, if you look at the breadth of this amendment, it appears to apply to all group health plans. While an EPO plan is a group health plan with no non-network coverage, it is a group health plan nonetheless. So, my best guess at this point is that there would be an expectation that there would need to be coverage extended in the non-network setting there.
Oh, sorry. Ben, on the short-term disability front, you talked about, there being a 7-day elimination period. Would it be possible for employers to waive that elimination period?
Certainly. I mean, you can do anything right now, right? Subject to certain parameters. But I think the things that are important to keep in mind are, again, back to, is this an insured or self-funded plan? Because certainly if it's insured, there is another payer in the picture that you need to get aligned with. Number two is whether and to what extent you do this in a way that minimizes the precedential impact for future non-COVID related claims. And then the final thing just to keep in mind here is that oftentimes short-term disability benefits bleed into long-term disability benefits. And most plans have set it up so that there's an integration between the disability determination and so on and so forth. So even if it is self-funded, if you're bleeding into long-term disability, just consider those flow-through implications for those purposes.
All right. Well, thank you, Ben and Jen. I do think we, at this point, have to move on to talk about the very real issues what employers are struggling with respect to managing their workforce during this time. So some employers are considering reductions in hours or furloughs or straight up severances. So Kaylee Ventura is going to take us through the benefit side implications of those kind of decisions. So Kaylee?
Perfect. Thanks, Diane. And as Diane mentioned, in these uncertain times, a lot of businesses are grappling with workforce management issues and considering various employment actions ranging from terminations to furloughs to paid or unpaid leave. And just to start off with some terminology so we're on the same page, I think a termination is pretty straightforward. That's anticipated as something that's more permanent and sort of an ending of the employment relationship. There's also a lot of employers are considering furloughs, which that term is used differently. It can refer to anything from a reduction in schedule to a reduction in schedule and pay together, to a full layoff where you're not working at all and receiving no pay. And it can be similar to an unpaid leave, but again, it's used a little bit differently, but it's usually viewed as temporary as opposed to a termination. And then there's, of course, leave comes into play, and that would occur in accordance with any leave policies you already have. We won't get into some of the paid sick leave and paid time off rules, as Diane and Ben mentioned earlier, but these are all just different shades of the same thing, which is, essentially reduced or no hours and reduced connectivity to the employer. An important point when you're considering any of these employment actions is whether you have a severance plan in place, which a lot of employers do. That might include some monetary assistance when employees are terminated or laid off, and you'll want to just check the terms of that severance plan regarding eligibility to see if employees who are maybe just being temporarily laid off or furloughed, if they qualify for severance benefits. In our experience, most severance plan would exclude temporary layoffs or furloughs or other, just reductions in hours that don't amount to a full termination of employment. But that's not required, and you might decide that the loss of income associated with a furlough may be an appropriate circumstance for offering severance to impacted employees. But the important thing is to, follow the terms of your plan or to amend it as needed to reflect your intent regarding eligibility. And if you don't have a severance plan in place, it might be a good time to explore establishing a plan if you do want to provide for some type of severance payment in the event of termination, layoff, etc. And as many of you know, there's a lot of benefits to offering severance in the context of an ERISA plan, and in most cases, if you're offering severance benefits, it's going to be an ERISA plan anyway. But in this context, we especially think it would be helpful to have the benefit of the internal claims and appeals procedures that come with a formal ERISA severance plan. But in short, the important thing is you've got a lot of flexibility in your severance plan design, and you'll just need to look at the terms or determine whether any amendments are needed. And just also in connection with severance, employers are going to have to consider whether the federal WARN Act or a state mini WARN Act is triggered by whatever their contemplated employment action is. We're not going to get into the specifics of when these federal and state mini WARN Acts might be triggered, but if they are triggered, they can often result in some type of pay or pay in lieu of notice. And while you can't reduce the actual WARN obligation because that's statutory, you can reduce the voluntary severance benefit by the amount of that WARN obligation, essentially making it part of your severance formula. So that's something just to keep in mind as you're reviewing your severance plans. And we're also just going to... Sure.
Hey, Kaylee, if you don't have a severance plan in place now, can you create one to deal with this situation?
Yeah. You can establish a severance plan at any time in order to deal with an upcoming termination or layoff. That's completely fine. You'll just want to communicate it to employees in advance and just go through all of the steps of establishing that and determining what level of benefits you want to provide. And that can be done, relatively quickly if you've got sort of all parties on board. Yes, not too late. So from there, I'm just going to move on to another topic that we've been receiving a lot of questions about in the context of various employment actions employers are considering, and that relates to health and welfare benefits and whether those benefits will continue in the event of these furloughs, layoffs, reductions in hours. And the starting point for this particular analysis is really the terms of your plans, as well as insurance policies. You'll want to check those regarding eligibility, and in all cases, an actual termination is going to trigger a loss of coverage, and that will result in corresponding COBRA rights, as well as for fully insured benefits, portability or conversion rights also come into play. If you're just furloughing employees, or reducing their hours, something short of a full termination, then it's not, that in and of itself is not necessarily a COBRA qualifying event or a loss of coverage, but the associated reduction in hours might cause a loss of coverage depending on what your eligibility requirement is, and that could then trigger COBRA. And this is a little bit complicated by the Affordable Care Act, and as most of you probably have health plans that provide that regular active employees who are working at least 30 or more hours per week are eligible for coverage, and you may not provide coverage beyond that. So if an employee's hours drop below the 30-hour threshold, or they're otherwise laid off or furloughed, that would typically trigger a loss of coverage under the health plan, and then that would trigger COBRA. But if you're providing coverage to employees based on service completed in the prior year, so if you're using the measurement and stability period rules under the Affordable Care Act in determining full-time status, then you may be, even if they have a reduction of hours below that, say 30-hour threshold, you may still be required to treat them as a full-time employee for the remainder of the stability period, which is often a 12-month period, and that would extend beyond during their reduction in hours period. And then in that case, COBRA might not be triggered. As I mentioned, it could be that your plan does terminate coverage at that point in time, in which case COBRA would be required, and that would meet the Affordable Care Act requirement that you offer some coverage to employees, but usually that would still result in a penalty because the COBRA coverage wouldn't be affordable. But you could decide to offer a COBRA subsidy to get around that issue, or otherwise reduce the cost of the full cost of the COBRA coverage to avoid that issue. You'll also want to, for both fully insured benefits and self-funded benefits that have stop-loss insurance, you'll want to coordinate with your insurance carriers regarding, employees who are on layoff or furloughed. You'll want to check for fully insured benefits the terms of your insurance policies regarding the eligibility criteria and see just how these events are dealt with. Often we'll find that leaves are covered and benefits continue in those situations, but they don't necessarily contemplate a furlough situation, so that may be something to confirm with your carrier. In addition, if you've got self-funded benefits with stop-loss insurance, that coverage is typically tied to the plan document's eligibility provisions, and you may need to confirm with a carrier their position on those eligibility provisions if they're unclear what happens in this situation. So definitely important to speak with those carriers so that you don't get into a situation where you're, bridging coverage, providing coverage for employees who are in, have had reduced hours or are on furlough when they wouldn't otherwise, when those carriers wouldn't consider them eligible.
So Kaylee, there's a lot of questions on that aspect that I see coming in. So just I think in summary what you're saying is if you have a self-insured medical plan, you have a lot of flexibility to provide coverage for people who would otherwise lose it, given whatever is occurring with respect to their hours, but check with your stop-loss provider. And if you're fully insured, you're kind of limited as to what the insurer will or will not allow, but approach them and see if there's an ability to extend coverage.
Exactly. Yeah, and on the fully insured piece, sometimes that's because there's an actively at work requirement for things like your life insurance or long-term disability, and that can be an issue, of course, if the employee is on furlough and they're not working at all. So that's why you need to coordinate with the carriers. And on this point, we do know that some state insurance departments are issuing some guidance where they're requiring the insurers in that state, and that might include stop loss carriers as well as just other insurers for fully insured benefits, to at least make that continued coverage available to their employers, their clients. We don't, for example, we saw a bulletin in the last couple of days from the state of Ohio Insurance Department, basically mandating insurers to allow employers to continue coverage for employees in these situations, even if the policy otherwise wouldn't permit it. We don't necessarily read that as requiring the employer to extend that coverage, but just if they want to, the carrier would also have to do that. So that's something just to be aware of, and other states may follow suit.
Thanks.
So exactly. So if you to reduce some of the adverse impacts of these events on employees, if you do decide to bridge benefits, important point is to check your plan terms, because amendments may be needed, and to coordinate with your insurance carriers for stop loss and fully insured benefits. And you'll also need to consider how employees will pay for premiums while they're on furlough or layoff. You can require employees to pay premiums post-tax through a direct cash payment, or you can recoup premiums upon return. You might want to coordinate this with how you'd otherwise handle an unpaid leave, because you should have policies for that context already, so that you may want to just look to those policies when determining how they're going to pay for this coverage. And if you decide not to bridge benefits, then another way to reduce the adverse impacts on employees are to subsidize their COBRA coverage. You can do that for a period of time or for the full COBRA period. You'd otherwise want to follow the normal COBRA procedures. It's just that the cost would be reduced, and that's fine as long as any subsidy isn't favoring your highly compensated employees, which is a term of art in this context. Otherwise, if you are trying to narrowly offer it just to highly compensated employees, that subsidy would be treated as taxable wages. So you definitely want to offer this more as a broad-based benefit to employees who are in these situations. And just in general, you'll want to, if the reduction in hours or layoff is a loss of coverage under your benefits, you'll just need to be mindful that you are working with your COBRA administrators, your insurance carriers, so that they can timely notify impacted employees. And so because COBRA could be triggered, portability conversion rights could be triggered, and all of those have notice obligations, and you certainly don't want to have a foot fault there where you're not timely notifying employees and potentially on the hook for penalties or other lawsuits for missed notices. And then just the last point is the impact of these types of employment actions on flexible spending accounts. If employees are having their pay completely reduced, they wouldn't have any current compensation, and so their contributions to FSAs wouldn't continue. But the full amount of what they decided to withhold for the plan year would still need to be available to them. That's a rule under an IRS rule under for these types of accounts. You still need to make those amounts available to them. And for dependent care, flexible spending accounts, just be aware. I think Ben noted this earlier that one of the requirements for expenses to be reimbursed under that type of account is that the employee needs to be working or looking for work. So just be aware that, that requirement may not be met if the employee's, furloughed and not working.
Okay.
Diane, I don't know if there are any other questions.
Well, I think given the time, we'll move on to the retirement plan section. But I did, for those in the audience who are looking for CLE credit for this program has been approved for CLE credit, so I'm going to read that code right now to the folks on the line. And that is S as in Seyfarth, S as in Shaw, 7721. So again, SS 7721 is the code for CLE. And then now I think we'll move over to our retirement plan arena. So whether you're handling 401k plan concerns or pension plan questions, there's also numerous impacts on this side of the benefits house as well. So Jake Downing is going to start us out by covering 401k. So Jake.
Thank you, Diane. And hi, everyone. On the defined contribution side, I want to focus on three elements. The first being plan investments, the second being employer contributions, and the third being employee access to the funds in their 401k defined contribution vehicle. On the investments, clearly we've all experienced significant losses over the last couple weeks in terms of the value of our 401k plan assets, and public companies with company stock funds in their 401k plans have seen significant reductions in that particular vehicle. There's obviously nothing any of us could have done about that, but we're now faced with those reductions. And not to be crass about this, but in the after part of this whole crisis, companies will get sued because of the investment losses. There's no way around that. That happens in every significant downturn that you see an uptick in that litigation. So what can we do? The first thing we can do is we can communicate and educate our participant population as to their plan investments and their opportunities. The second thing that we can do is that we can redouble on our process to the extent we have any bandwidth. So plan fiduciaries, committees, and those responsible for watching and monitoring the 401k plan investments need to meet, discuss their lineups, and come to resolutions as to whether a change is necessary with respect to those lineups, and also if no change is necessary, because we come to that decision, documenting why no change is necessary. As we've said to many of you who are our friends, process is key in the ERISA fiduciary space. It's less about result, but you can't point to a process if you haven't met in light of these extraordinary circumstances and you have not resolved one way or the other. If you do that, the law puts the decision on whether to continue a particular investment or change course on the participant. So we're all relying on what's called ERISA 404C protection and putting the responsibility of those plan investments on the participants. That's not going to be enough at the end if we don't communicate clearly And if we don't meet and follow a process to support why we're currently doing what we're doing and why we're going to do something different or stay the same. So I don't have a magic solution there. We're all going to be faced with these losses should the market not rebound quickly. The second piece of this puzzle is contributions. So the first bullet under the contribution component of the slides relates to force majeure defenses or impossibility defenses to making employee contributions timely to the trust. We anticipate that some companies will struggle or have a challenge in this particular environment in meeting that obligation. I don't have any crystal ball in terms of relief, but we have to just do the best we can to get employee deferrals to the trust as soon as we can, knowing that the 1 day or 2 day time periods that we've been operating under may not be realistic going forward, or at least in these next weeks as we move through this crisis. The second question that we're getting the second point that we're getting a lot of questions on is, what can I do to reduce my employer contribution to the 401k? And in that space, if you're a non-safe harbor plan, meaning you have a discretionary matching contribution or non-elective contribution, generally those are not protected benefits, and you can remove them, reduce them, and treat them as you see fit given the current cash flow constraints on our clients. On that point, the only thing to be mindful of is any year-end true-up contribution of the 401k plan that may already have been vested for someone who retired or became disabled or died. Certain of those individuals will have an accrued or vested benefit, that will need to be honored, but the rest can have that benefit reduced or eliminated. If you are offering a safe harbor 401k plan, you're more constrained. You need to give 30 days notice of the suspension in the 401k matching contribution. And even in order to do that, you need to satisfy two conditions, or one of these two conditions. Either you've reserved the right to do that in your annual safe harbor notice, which many of you will have done. If you have not reserved that in your annual safe harbor notice, you'll have to document economic loss as the reason you're reducing the match or eliminating the match. That's a squishy term under current law, but I imagine many of you will be able to meet that. One thing I want to touch on before I get to the distribution alternatives, because I think that's key because it's part of the legislation, is that anytime you have a reduction in force in a particular year that amounts to a 20% reduction in the participants in a 401k plan, there is the potential for that to trigger automatic vesting of all current contributions to the plan, and we'll anticipate many of those events occurring in the near term. We don't have any relief from that presently, but we will see. On the distribution alternatives, I think this is where we can help our employees if these laws get passed. There is pending relief to allow access to the balance for hardship withdrawals that would not be subject to the 10% early withdrawal penalty. And there's also the expansion of 401k plan loans to increase the eligible loan amount to as much as $100,000, and also relief for people, going back to Kaylee's presentation, that were impacted by a RIF and are unable to continue to pay back plan loans. What's being proposed is relief in that situation such that there would be a delay in when they need to make those repayments and a new amortization of when they'd need to catch back up on those payments to avoid what would ultimately be backbreaking deemed distributions with the associated taxes and penalties. So with that, and given the time, I'm going to kick it to you, Christina, to address what we're seeing in the defined benefit space.
Thanks, Jake. I'm going to just take a quick second on this slide. We do anticipate that some DB plans will have significant funding challenges next year because of the zero interest rate environment. I have seen in the Pelosi bill that came out about an hour ago that there is some single employer funding relief that has been proposed. I know this has been lobbied heavily. We would also welcome any PBGC premium relief, although I didn't see that yet. But I do know, again, that it's being lobbied for. If you do have a DB plan, understand and pay attention that shutdowns RIFs could implicate PBGC reporting. Also, you might have in a multi-employer plan context withdrawal relief. And then on the last bullet, just as a going forward basis, this, depending on how long this situation lasts, we could end up in a situation with PBGC going back to employers when they report asking for escrow, doing distress terminations, involuntary terminations. So we do see that coming down the road, although we hope for some at least of the funding relief and I would also hope for some of the partial termination, full vesting relief. Also wanted to touch on just a couple of general retirement issues that we know are going to come up. We're prepping for the audits for Form 5500s. These are getting to be impossible. Late Form 5500s are going to be common. We know that we are hearing that lobbying again is happening to extend these deadlines on a anecdotal case-by-case basis. We have seen deadlines for particular agents extended for just individualized plan audits as well as determination letter and other types of filing responses. Jake already discussed the scrutiny of plan investments and plan investment strategies on the DB side. When I echo Jake, do some process, take a look at your investment policy statement, see if it still makes sense, and document that process. Lastly, just wanted to point out for DB plans in a situation where people will want to perhaps elect a lump sum after termination or something and they need some sort of spousal consent. We have seen states, a handful of states starting to permit notary over a telephone or other type of electronic means. We expect there will be more states if this situation does come up. However, we do think there has to be some sort of on a case-by-case basis determination as to whether or not not having an in-person notary requirement really does put the plan at risk before the state waives that requirement. And hopefully, Jake, I gave you a little bit of time to address the exec comp issues.
Yeah, thanks. Jake, you'll have a few minutes left, 7 minutes left to talk about the concerns that have risen in the exec comp space, because many employers have unique provisions or plans and programs for this portion of our workforce. So they're not insulated from the impacts we see going on either.
No, and I understand that this may not be the most sympathetic or the poster for what we're trying to do in this space, but it's still meaningful to the individuals that are impacted. So a couple of things I want to touch on in this short period of time is, if you haven't done your 2020 annual or long-term incentive grants, you need to start over or at least revisit both the number of equity grants you're providing, the performance metrics that you're using, and to the extent you can build in under your current documents and your current governance structure the most flexibility that you can provide, both in terms of the metrics and when amounts are paid, the better suited you will be. Many companies have already done 2020 grants, and they are at present left with those grant provisions because they are contracts. That said, we would anticipate flexibility to revisit those metrics, revisit the values of the grants outstanding. And this really goes to 2020 grants that are already issued, or 19, 18, 17 grants that may need to be revisited in light of an entirely changed framework for when they would pay out. There are going to be a host of challenges for revisiting grants, from SEC disclosures, potential shareholder approval, public optics, but we've worked through that before, and there are solutions to make those grants more palatable given the present environment. The other thing I want to raise is that we are seeing across the board reductions in executive salary and executive bonus opportunities, and generally speaking, that's permissible under state wage and hour law. But you have potentially underlying contractual promises that if you reduce salary by 11%, that may trigger a good reason severance event, or that salary may be contractually obligated based on an underlying employment agreement. In those situations, you have to address that on an individual by individual basis to avoid unnecessary disruptions to your workforce, but also your cash outlays for severance. You don't want to reduce salary only to have to pay somebody that full salary for 12 months, 24 months in extreme situations because you just unilaterally pulled the trigger on a across the board executive salary reduction. The last point in there's a lot here, and I apologize, we're just not going to get into the details on that stuff. But the other key issue for us is that you have a lot of non-qualified deferred compensation out there that is unfunded, meaning there are no assets available to pay. And when you pull the trigger on RIFs, furloughs that reduce employees' hours or put them out permanently, that could trigger separation from service distributions en masse, and you don't have the cash set aside for that. In the furlough unpaid leave environment, if the true intention is for this to be temporary, we don't think that should be a separation from service triggering a distribution until that person has been gone for 6 months. So that gives us some flexibility there. We would also imagine unforeseen circumstance claims coming up where people want access to what could be sizable distributions as a result of their current economic circumstances, putting more stress on that system. Code Section 409A, which governs all of this, is an inflexible statute, but what we can say is let's preserve the business first. 409A was designed for the purpose of not allowing executives to raid these programs in this type of situation. It was not designed to prevent companies from holding assets to remain in business for their rank and file employees, even if that may be an impermissible deferral. I'm not providing legal advice, obviously here, but we want to err on that side of this equation as opposed to accelerating distributions. We need to be very careful about accelerated distributions in this space given the current environment.
Right. Thank you, Jake. That almost takes us up to the top of the hour. We have a number of questions that we weren't able to get to, some of which, though, I'll point out are questions that are going to be hopefully answered on our Wednesday webinar, which is more employment side, sick leave, unemployment insurance, FMLA issues under the Family First Act, and maybe some news on whatever might come out of the Senate and the House side. So please be sure to register for that. Other questions, I saw like an I-9 question in our list of questions. Some of those, if you, again, another informational place for you to go would be the Seyfarth website for our COVID-19 external facing toolbox. There's lots of information in there. We've been putting out multiple blogs and legal updates daily. We've been collecting those and daily push-outs to our clients who've signed up for that COVID-19 Resource Center. So some of your questions might be answered in that collateral material that's out there as well. I apologize for jamming so much into an hour. Thank you, everyone who stuck with us. We really appreciate your time and attention, and we wish everyone, of course, the best of luck. Stay healthy, everyone.
Thank you. This concludes today's webinar, and we thank you for attending.